important when you are asked questions that the lawyers, the court reporter, and that I can all hear you. During the jury selection portion of these proceedings, counsel and I will ask you questions, so again, keep your voices up. Thank you for your presence here today. We recognize that each of you is making a sacrifice to be here. It's the court's intention that service as a juror or prospective juror be a rewarding experience, even though the monetary compensation is minimal. Service as a juror is one of the most valuable civic duties you can perform. Trial by jury is one of the most valuable rights we possess. Your participation in this process contributes greatly to the fair and equitable administration of justice. You have been summoned as prospective jurors in a felony criminal case captioned "The State of Ohio versus Raymond Tenzing." A criminal case begins with an indictment. The indictment informs the defendant that the state has charged him with one or more offenses. Each count of the indictment asserts a separate charge. The indictment is not evidence that the defendant committed any offense. The defendant, Raymond Tenzing, pled not guilty to the indictment. That includes each and every count or charge in the indictment. His not guilty plea denied the charge and requires the state to prove each charge beyond a reasonable doubt. The law presumes that the defendant is innocent unless and until the state proves the defendant's guilt beyond a reasonable doubt. Jury service may be strange to some of you, so a short explanation is in order. Those who participate in a trial must do so in accordance with the established rules. That is true of the witnesses, of the lawyers, and of the judge. It is equally true of you, the jurors. The lawyers present the evidence according to the rules. The judge enforces the rules and determines what evidence may be admitted. You collectively as jurors will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony. You will receive the facts from the witness stand. Instructions as to the law will be given to you by the court, and it is your duty to accept and apply the instructions as given to you. The plaintiff and the defendant are entitled to jurors who approach this case with open minds and who agree to keep their minds open until a verdict is reached. Jurors must be as free as humanly possible from bias, prejudice, or sympathy and not be influenced by perceived ideas either as to the facts or as to the law. A trial starts with the selection of a jury. As prospective jurors, you will be questioned to determine your qualifications for this case. These questions are not designed to pry into your personal affairs, but to discover if you have any knowledge of this case, or any preconceived opinion which you cannot set aside, or if you've had any experience in your personal or family life that might cause you to favor either party. These questions are necessary to assure each party a fair and impartial jury. You are undoubtedly qualified to serve as a juror. However, there may be something that could disqualify you for this particular case. Since this is an important part of the trial, you are required to be sworn before questions are asked. At this time, I will ask you to stand and raise your right hand. You do solemnly swear or affirm that you will truly and fully answer all questions put to you by the court and counsel in this case now called for trial, and this you do as you shall answer unto God and under the penalty of perjury. Please say, I do.
I do.
Very good. You may be seated. I will introduce the parties in this case. As I introduce you, please stand for a moment so the prospective jurors can see you better. Representing the state of Ohio is the Hamilton County Prosecutor, Mr. Joseph Dieters. Along with Mr. Dieters are his assistants, Mr. Mark Pietmeyer and Mr. Rick Gibson. The case officer representing the state of Ohio in this case is Mrs. Shannon Hine. Representing the defense are Mr. Stuart Matthews and Ms. Gwen Callender. Along with the defendant, Mr. Raymond Tenzing. Ladies and gentlemen, please listen closely to the questions, and if you are silent in response to the question, it will indicate a negative answer. If, however, any one or more of you believe your answer to be otherwise, please get my attention or the lawyer's attention and let them know that. I will begin by asking some general questions. If my question calls for a personal answer, which you would prefer to discuss in private, just say so and we can step into chambers. Of course, the lawyers and the court reporter will be joining us. My initial questioning will be to all prospective jurors present in the courtroom and not just those seated in the jury box. I've introduced you to the parties in this case. Is there anyone who is personally acquainted with anyone I have introduced? Okay. Yes, ma'am, right there. Okay. What is the nature of your relationship?
I work for Kroger, and she's worked security, and she's also worked at security entities. I think they'll we're familiar with each other.
Okay. Would that relationship cause you to not be able to be fair and impartial in this case to both sides? It could possibly. Okay. I'm sure that the lawyers will want to inquire about that. Okay. Who else? I thought there was somebody else over here. No? Anyone else personally acquainted? Very good. We anticipate, as I had previously told you, at the very longest, this trial would be until November 18th. Again, I would be shocked. Is there anybody who has discovered a problem since we last spoke with the time frame of this trial? Great, good. We will recess. Oh, sorry, I missed you. Yes, ma'am.
I can't hear, I'm sorry. My reporter, the first 2 weeks, the personal contact with that.
Okay. Would it be a financial hardship for you if this case went over those 2 weeks?
Well,
Okay. It would be. Okay, very good. The lawyers may want to inquire of you about that. Again, I mean, I would be shocked, but I also don't want to put you in a bad position. Oh, I apologize. Your juror number. Do you know what your juror number is? 34? Yes. And what is your juror number, ma'am? 11. 11 in the box, 34 in the back. Okay, great. As I had previously told you, we will work, once we have a jury, on a 9 to 1-ish schedule each day. Does anybody have a problem with that? Great. Does anyone otherwise believe service on this jury would cause a financial or personal hardship? Yes, sir.
Yeah, if the jury was sequestered, I couldn't do that. I would tip the employee about that.
Okay. So you are unable to be sequestered once deliberations begin. It would only be for deliberations. It would not be for the whole case. Would that create a problem for you if it were a couple of days? It could? And that's a financial hardship? Is that what you're telling me? Okay. 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 And you are juror number 2, correct? Very good. The lawyers may want to inquire about that. Okay. Does anyone have any infirm or dependent family members who would require your attention, causing a conflict with this schedule? Any doctor's appointments, anything like that? Okay. Does anyone have any physical, emotional, or mental problems which would prevent you from serving as a juror in this case? From now on, my questions are directed to only those prospective jurors in the jury box. Now, also, when the lawyers get up to ask questions, they will be directed to only address the 12 people in the jury box. What that means to the rest of you is you have to make a mental note. If I ask a question or if the lawyers ask a question that you feel like we need to know an answer to, you need to bring that to our attention if you get called up to the jury box. Have any of you, to the best of your recollection, read or heard anything about this case? Is there anyone in the jury box who is not? Very good. No? Excellent. All right. And you are juror number 14, correct? Very good. Okay. Now, I don't want you to tell me what you've heard or read. What I need to know is, are you able to set that aside and make a decision based solely on what you hear in this courtroom? And I'm going to start with juror number 1.
Yes.
Juror number 2. No. The lawyers will want to ask you about that. Juror number 4. Juror number 6. Juror number 7.
Yes.
Juror number 9. Juror number 10. Juror number 11. Juror number 13. Don't know. Okay, fair enough. Like I said, we're just getting to the preliminary questioning, so the lawyers will explore it with you. Juror number 14. Juror number 16. Juror number 17. Very good.
Judge, can I ask a question before we get to the further?
Sure.
You will do a panel with the
Okay, so you're right. So we should,
first 19 and 20 should actually be up there as well.
very good. Juror number 19 and juror number 20. And you can take those seats over to the side. Thank you, Mr. Gibson. Ultimately, yes, but that during this phase, the way we did the math, if we do 14, 14, and then remainder. But I hear what you're saying. The last 2 jurors that we called up, I'm sorry, your numbers are 19 and 20. Juror number 19, have you heard anything about this case or read anything about this case? Very good. Juror number 20.
Yes.
Would you be able to set anything that you've heard or read aside and make your decision based solely on what you hear in this courtroom?
Yes.
Very good. Is there anyone here who does not believe that he or she could render a judgment in a case for whatever reason, moral, religious, philosophical, that you cannot sit in judgment of another human being? Very good. Both parties want a decision. If the state proves beyond a reasonable doubt the defendant's guilt, can everyone here sign a guilty verdict? Likewise, if the state fails to prove beyond a reasonable doubt the defendant's guilt, can everyone here sign a not guilty verdict? You must decide this case based solely on the evidence produced at trial, and you must decide this case only after discussion with your fellow jurors and after a fair and complete consideration of the views of all jurors. This is a careful and deliberate process. Can and will each of you participate in a group decision-making process of this sort? Is there anyone here who feels that they cannot or will not participate in a group decision-making process? In arriving at your verdict, can each of you lay aside such matters as race, religion, or sympathy? None of these must have any effect on your deliberations in this case. Is there any one of you who cannot lay aside such matters as race, religion, or sympathy? Do each of you understand and agree that your verdict must be based solely on the facts as testified by the witnesses, the exhibits that are admitted into evidence, and the law as given to you by the court? Very good. You've heard me use the phrase reasonable doubt a few times, so I'll define it for you so you have some basis going forward of knowledge. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Is there any one of you that cannot base your verdict solely on the facts as testified by the witnesses, the exhibits that are admitted into evidence, in the law that is given to you by the court, knowing this is the definition of reasonable doubt? It's a pretty compound question. Ladies and gentlemen, many of you expressed concern over serving on this jury via your questionnaires. Your concerns are understandable, but I want to assure you your identity will be kept confidential. Whether you end up serving on this jury or not, we do not publish your identity. The media is under strict admonition not to capture your image at any point during this process or throughout the trial. If they would, there are staff watching the live stream. It will be immediately brought to my attention, and the media will be permanently removed for the remainder of these proceedings from the courtroom. Any juror captured on video would be given the opportunity to quit serving on this jury at that time. Your voice may be picked up during this phase, during questioning, but that is even questionable since the jury box is not microphoned and none of you have microphones. The likelihood of being ID'd by your voice, I would say, are slim and none. Further, other measures will be taken if you are selected to serve on this jury to ensure you remain anonymous. Without getting into details, rest assured that you will not be subjected to any of the goings-on outside of this courthouse. I can assure you of that. At this time, counsel for the parties are permitted to continue inquiry of the panel. Counsel for the state is permitted to first make such inquiry, followed by counsel for the defense. I would ask each counsel to review your potential witness list for the prospective jurors to determine whether any of them have personal knowledge of any of your witnesses. State of Ohio, you may begin. Please. Feel free to move freely about the room.
Good morning, everyone. Glad to see that everyone made it back. It was a spectacular weekend, and I hope everyone got a chance to enjoy it and not think about this case for a little while. Maybe watch the Bengals go all the way to London to play to a tie. Let me make sure that I understand who I've got in a jury box and who I'm talking to at the outset, okay? That's probably isn't a big deal to you where you sit, but it's a huge deal to us. If we go across the top, I think we have juror 1, 2, and 4, 6, 7, and 9. Is that all correct? All right. And on the bottom, we have jurors 10, 11, and 13, 14, 16, 17. Is that correct? All right. And we have 19 and 20. Okay, good. That's very helpful. At least I know who I'm dealing with. Tim will do a good job keeping you lined up and where you're supposed to go. A while back, I had a trial that I did in another courtroom where we had a new bailiff, and he didn't know people were supposed to be in order. And so when we started talking to the people, and it was, after a while, it was almost comical. And it was like almost like they had shuffled the deck of cards. And I think I'm talking to the 5 of clubs, and I'm talking to the 8 of hearts. So you can imagine that. It'd be helpful if you just remember who you're sitting by and help Tim out in that regard to make sure everybody gets where they're supposed to go. Let me introduce myself again. I'm Rick Gibson. I'm an assistant Hamilton County prosecutor. I was hired in the office in 1983, right out of law school. Same year Mr. Dieters was hired, I think. When we got there, Mr. Pietmeyer had already been in the office for 3 years, I think, plugging away. So we've been at this a long time. I know probably last week, the day you came in, you all saw a video. Is that accurate? Mr. Sykes showed you a video. And did it help you to understand what to anticipate in jury service and what you might be asked to do? Okay. Then you know in this part of the jury selection process, what we call voir dire, we get to ask you questions. Does anybody have a problem with that? Anybody okay with that? I mean, your questionnaires, these aren't the usual questionnaires that we use, as you can imagine. They were very helpful. We found out a lot about you, and that's a good thing. But there are some questions that might be raised by the answers in the questionnaires and some things we might want to ask. Is everybody okay with that? I know some people are shy. Some people don't like talking in big groups. Everybody has their fears. I don't like heights. Some people are the same way with talking in a public setting. Everybody okay if we ask you questions? One time I asked a juror question, and he just folded his arms. He says, "Why am I have to answer questions? I'm not on trial." But you understand the importance of it. If we're to pick a jury, we have to, it's going to be fair to both sides, we have to know a little bit about you, and Mr. Matthews has to know a little bit about you. So if we ask you questions, everybody going to be all right with that? All right. And again, as Judge Shanahan indicated, here's how we're going to try to do this process, and it'll streamline it and move it along a lot quicker if you'll help us with it. I'm going to focus on the 14 people I have right here in the jury box. That's who I'm going to ask my questions of. And I'm going to try to ask the questions of you as a group. Two things you can do to help. One is if a question sparks something in you, makes you feel a need to raise your hand or to respond. You've been very open, and again, I appreciate that. It's so helpful. If there's something you want to answer to, or let us know what you think or what you feel, would you raise your hand? And again, as was said, keep your voice up, okay, because we have a court order that needs to make a complete record, okay? Can everybody hear me? I'm used to these courtrooms are big, and when you try cases, you get used to talking loud, like the judge said, stage voice. When I go home, my wife, they always ask me why I'm screaming, because I've been in court all day, and you just tend to talk loud in here. Keep your voice up, because it is important. We do need to make a complete record. Now, for the people that are in back, you might think it's a good time to take a nap, since I'm talking about these people that's not. Please do me a favor. Follow along, listen to all the questions that are asked, because when we're done with this group, the next group is going to come up and take their seats. And we'll repeat the same questions so that we don't have to go through all of them. You'll know a little bit of what's coming, and you can be prepared and give us answers. Is that all right, everyone? Okay. I want to stress to you, when we ask these questions, we're not trying to pry. I hope you all appreciate that. Like I said, you've already been very open and very helpful in your questionnaire, so thanks very much for that. Judge Shanahan talked about some things that you're not to consider, or not to let enter into your deliberations, and she said, I think, race, bias, things of that nature. There's another one, punishment. The judge is going to tell you as part of her final instructions that if you sit in this case, you're not even to think about what possible punishment might follow if you find the defendant guilty. I think that's probably a hard thing to do. I mean, I think if I was a juror, I'd probably wonder, if I sign that guilty verdict form, what's going to happen to the guy sitting at the table with me? Not even allowed to think about it. Can everyone do that? The judge is going to tell you that what punishment, if any, would follow a conviction is her responsibility. You're here to listen to the evidence, determine whether the evidence and the law indicate that the defendant is guilty or not guilty. Can everybody do that? Put any thoughts or considerations of punishment out of your mind. Everyone? This case has gotten a lot of media attention. Almost every questionnaire, just so you know, well, you guys were on, after you did your questionnaires last week, we got them the next day, and we've been reviewing them since. So you can imagine how long this has taken. But almost every questionnaire I read, the juror had some knowledge of this case, either because they saw it on the news or because somebody talked to them about it, at church or at a corner pub or somewhere. It's hard not to hear about this case or know something about it. Everybody agree with that? Now, that doesn't disqualify you. We like an informed public. We like citizens who know what's going on and who follow it. That's fine. It doesn't disqualify you unless you have already formed an opinion as to guilt or innocence, and you can't set that aside. Okay? Do we have any people that have, as a result of the media that they've seen or anything like that, that have already, as you sit here now, you've already decided either that Ray Tenzing is guilty or that Ray Tenzing is not guilty? Okay? Couple? All right. Let's go through those. We'll start with juror number 2. I didn't think that you noted that on your questionnaire. Did you think about this more over the weekend or something? Okay. Was it an issue where somebody talked about it in front of you? Did you see additional media coverage?
I watched the movie and it made me think really more about it.
Okay. When Judge Shanahan asked all the jurors if you could sign a guilty verdict if the evidence convinced you beyond a reasonable doubt of the defendant's guilt, you indicated you could just now. Can you do that? All right. So even though you have some opinions as to the things you see in the media, if the evidence convinces you beyond a reasonable doubt, you can find Ray Tenzing guilty. evidence does not convince you that he's guilty, can you sign a not guilty verdict form?
I think, yeah, I could, as a person I am, but I would think that, you know, where I stand, I would be someone to be excused. You know,
Okay. Okay.
not to be put into that position.
Okay, well, I appreciate that. And at the end of this process, I'm sure they showed you this in the video that you saw, we'll get a chance to excuse a certain number of jurors, and the defense will get a chance to excuse a certain number of jurors. But what you're telling me right now, whatever your opinion is, you can decide this case on the evidence you hear in this courtroom and either sign a guilty verdict or a not guilty verdict, whichever is appropriate.
I understand I said yes a minute ago, but I'm not sure.
You're not sure?
Not sure
Okay.
with the current political climate.
Okay. All right. I saw some other hands. Juror number 10, what is your thought on it? You've already formed an opinion on guilt or innocence?
I think so.
Do you think it's possible that you could put that out of your mind? You understand it would be unfair to convict someone on what was said in some media account that you saw or something somebody told you. That the appropriate place to do it was in the four walls of the courtroom. Can you confine your verdict, in this case, if you sit, to what you hear in here during the course of the trial?
I don't know, because I've been on two juries already, and the evidence, you form pretty.
Okay. As jurors, you do despite the instructions you get from the judge.
No, but first couple of days, figure out who's.
Okay. So you can't sign a not guilty verdict. There's no way, no matter what the evidence is.
I think I could.
Okay. It's going to be a difficult case all the way around, folks. I don't want to sugarcoat that. But the question is, can you confine your decision to the evidence you hear in this courtroom over the next week or 10 days? Okay? Who was the other juror? Was it juror number 13? Yes, sir. What's your thought on that?
Well, like I said, I have talked with a lot of people about it, read things in the paper.
That's all okay. Can you put that out of your mind, though, when you sit as a juror? You're gonna see and hear the actual evidence in the case, and you're gonna evaluate that evidence and apply the law the judge gives you to that evidence. If the evidence convinces you beyond a reasonable doubt that he's guilty, then you sign a guilty verdict form. On the other hand, if you don't find that evidence compelling enough that it convinces you beyond a reasonable doubt of his guilt, would you sign a not guilty verdict form? Okay, so you could do that. Okay. All right, thank you. I appreciate it. Is there anybody else, anybody whose hands that I missed? Okay. Let me tell you a little bit about this incident. It occurred up in Mount Auburn. It occurred on a street called Rice Street, which goes up from Vine, Phil on one side, and Valencia in that block right there. Anybody familiar with that location? Okay. Yes, sir. Okay. Juror number 10, you're familiar with that? Okay. And it involved a traffic stop. Nobody's going to try to tell you that the stop was improper or anything it was done wrong, at least at the outset of the stop. That at some point that the defendant pulled his, he was a University of Cincinnati police officer, pulled his service weapon and shot Samuel DuBose, who was unarmed. Those are the facts. Now, the charges that you're going to be asked to decide in this case are murder first and aggravated and voluntary manslaughter. Those are the two charges you're going to consider. Now, there may be some lesser included charges, but it's murder and it's voluntary manslaughter. Murder is purposely causing the death of another. I want to make that clear to you. We didn't charge him. The grand jury did not indict Ray Tensing for aggravated murder. So, a lot of the commentary I hear and thing on that is that we can't show that he woke up that morning and decided he was going to kill Samuel DuBose and planned it and carried out. We don't have to prove all that. The indictment here doesn't contain any charge that requires proof of a prior calculation and design, or what we used to call premeditation. Again, all the state has to prove in this case is that the defendant, Ray Tenson, purposely, which means intentionally, as the judge will tell you, caused the death of Samuel Dubose. Does everybody understand that? Now, I think, ladies and gentlemen, we have the burden of proof. We have to prove that each and every element of the crime purposely caused the death of another, and in this case, Samuel Dubose. But, folks, I think what you're going to hear is this isn't a whodunit, and it's not an accident. It's a case where the defendant himself admitted in a taped interview with some St. Louis homicide investigators that he purposely caused the death of Samuel Dubose.
Understood. Look, let's stay away from the evidence, Mr. Gibson. The objection is sustained.
Ladies and gentlemen, I think the real issue here is going to be whether the homicide was justified. If the defendant wants to assert an affirmative defense, does everyone here understand that that burden of proof is not on us, it is on him? If the defendant wants to prove self-defense, that's a burden he bears.
And Judge, I'm going to ask that the jury be instructed to inform what the law is and who has what authority.
I'll allow some latitude on that. The objection's overruled.
Thank you. Juror number 9, do you have some idea of what it means when we say that somebody acted in self-defense? Yeah. Okay. And I expect that juror number 7, do you have some idea for that?
Yes.
Now, in this case, the judge is going to instruct you on what self-defense is. And she's going to tell you what the elements of self-defense are, what it is they have to prove to make out that defense. And that they do have to prove that they have the burden of proof. If the judge tells you that, juror number 7, can you accept that?
Yes.
What if it conflicts with what your thoughts or your ideas on self-defense are?
Judge, I don't object again. Can you first?
Yes. You'll be returned back down to room 580 for this. So I'll rise for the jury. Very good.
Yeah.
When you get a chance, just go stand and if you get a chance, I'll be watching.
When they come back in.
Okay.
So everybody, as long as they're going with it.